Hi everybody.
Hello there.
I'm Jerry.
And I'm Linda.
We're the village's newcomers. When you retire, hopefully you've built a nest egg. You have some assets. And then you go and move to Florida. And guess what? You don't know. Will Florida eat up some of those assets someday when you retire or you go to a nursing home or whatever? So we've asked some friends. We talked about it. We got all kinds of second and third hand information. We decided to find out from an expert. So I did my research. We went into the Nextdoor app and we found, almost above all others, one attorney had a glowing recommendations. So we contacted this attorney office and they said yes, they'd be on our show. So we're so thrilled. We're here in the offices of Amy Pittman. Thank you for having us over.
Well, thanks for having me. Hopefully y'all will learn something today.
Yes, ma'am, because we know nothing. We will learn something. And what a lovely office you have. I told Linda when we walked in here, this is really nice.
We try to make it where it's calming, not stuffy law firms. So we understand that coming in to see a lawyer can be stressful, intimidating. So we want them to think like they're coming into somebody's home, which is how we kind of set it up here.
It feels that way.
It's very homey.
When we came here, we thought we were all set. We had responsibly made a last will and testament, and we brought it with us, and we got here and people told us, hey, that's no good in Florida. So we made a list of questions today and we'd like to ask you, and I know that you're going to know the answers.
Hopefully.
Are wills from other states sufficient when you move to Florida?
It depends. And that's my answer for a lot of things. So when you do a will in the state that you were previously living in, it's based on that state law, right? And most of the time when you move, they look fine. In Florida, what is required in a will, even if it's an Indiana will or wherever, it's going to have a self-proving affidavit. And if that will doesn't have a self-proving affidavit, it's just going to make the probate process more difficult or time-consuming and more expensive. So most people are trying to avoid that cost or the time of probate, so they're going to update it. The other thing that people don't tend to realize is their situation is not the same. So they'll move here, they did their wills 10, 20 years ago, their kids were still little, and they think, oh, well, it's still the same. So most people end up updating their estate plan, not just because it's from a different state, but it's just not current to their situation. So we always recommend, we don't charge for a consultation. Bring your documents in, we will look at them, but we also are going to ask those questions. What's going on with your kids? What's with the assets, the type of assets you have, so we can determine if we need to do a will. Do we not need to update one? So like today I had a client came in, their wills were done 3 years ago. They're still valid, even if it says that they're residents of that other state. The situation was still the same. They still wanted the same people in charge as their executors. They still had the same beneficiaries, and it had the self-proving affidavit. So theirs was fine, but their durable power of attorney, their healthcare documents are going to have to be updated. So anytime you move from one state to the next, you're going to see what we call incapacity documents look different. So they're usually governed by the state. So state statute is going to determine what those documents say. So in Florida, our durable power of attorney, which is basically the document that's going to say, hey, who can be me when I'm incapacitated, is like 25 pages long. So you're not going to see that in other states. Florida changed their rule about 10 years ago on our power of attorneys, and they're extremely detailed. And that durable power of attorney in Florida is actually effective as soon as you sign it. So we want to make sure that that document is still good, because if you come into Florida and there's an issue and you don't have that power of attorney and you become incapacitated, it's too late and we have to do a guardianship. So anytime I have a client move out of Florida to another state, we always tell them to go talk to an estate planning attorney in that state to make sure their documents are still valid in that state and valid or to their situation, that their situation is being addressed, because things change. Most people think they see a lawyer, we don't need to see her again, or my kids will just have to deal with Amy when I die. Well, things happen where you just need to revisit it, and usually it's when you move or a spouse becomes incapacitated or dies or a kid passes away, you want to revisit those situations. So It just always depends. We say bring it in, we will look at your documents, but we know that your power of attorney, which is the financial day-to-day, the healthcare surrogate gets updated. Some states call that a healthcare power of attorney. That's who actually makes your medical decisions. The living will, which says, hey, I don't want to be artificially prolonged if you're in a vegetative state or in stage condition. So some will get updated, and it depends about the will. So your neighbors sometimes don't know as much as they think they do.
Okay. Could you repeat that?
I can.
You're using some legalese, and our guys probably don't know it because I don't know what a self-proving affidavit is.
So it's kind of like you signing in front of two witnesses, they sign, and then you signing again in front of the two witnesses.
Okay.
Most of them will say it on the will. The last page, it will say self-proving affidavit on the will. If it doesn't say it, then you're looking for you signing twice in front of two witnesses, and basically y'all three signing again, saying you signed in front of each other. That's what it is.
We had heard that you do a good job and that you don't push things that aren't necessary. So you just said that a will may be perfectly fine here if it's done properly before you get here.
Yep.
Now what we don't know is what is the difference between a will and a trust?
So, and again, you're going to hear more about revocable living trust, which is what you're referring to, in communities like the villages or retirement communities, because our kids are not local. The people we want in charge are not local. So a revocable living trust is what I call a will substitute. A last will and testament does not avoid probate. A will is just saying, hey, here's my beneficiaries of my assets when I'm dead that are going to go through probate. Well, what assets go to probate? Assets that are in your name alone. If I have an asset with my spouse's name, Josh, so Amy and Josh owns the asset, when I die, it's just Josh. He's the sole owner. He doesn't have to probate it. But if the asset just says Amy Pittman and I'm dead, Josh has to take my will to an attorney and they have to probate my will. And my will is going to say 100% to Josh, or if Josh predeceases me, equally to my two kids. So your will is just identifying who's getting your money and who's in charge. We call it a personal representative. And that is just covering those assets that you did not name a beneficiary. So when I look at clients' worksheet, because we email our clients or potential clients a worksheet asking about assets, I'm asking about what type of assets they have. I do look at a little bit about the value, but with the federal estate tax exemption being $11.7 million, the estate tax issue currently is not a big deal for most of my clients because they don't have $11 million. But when we look at the type of assets, I have an IRA, a 401k, a life insurance, annuities. Those type of products allow you to have a primary beneficiary, my spouse, and my secondary beneficiary. And if my beneficiaries are adults, if y'all have two kids, we're going to go 50-50 by two kids. Now, in my case, I have minor children, so I can't do that because my kids can't own anything right now. So I'm probably going to look at a trust for that reason. But again, most of your assets, if I'm trying to keep it simple and not do a trust and just do a will, the goal with the will is to reduce the amount of assets you have going into probate. So you're going to be directed by us to go to the banks, the financial institutions, and name beneficiaries. So most banks, checking, savings will let you do a beneficiary called pay on death or in trust for, and you're not naming them as an owner. So I don't want your kid on your account as an owner because then they may take your money or we may not like them and it's harder to get their name off than it is to get it on. But if I name them as a beneficiary, they don't actually take ownership until they show that bank a death certificate. So I can name beneficiaries on just about any asset. We don't really want to do that with your homestead property. So if it's the homestead property, then we've reduced the amount of assets going into probate, which is a much faster process if my house is going to my kids or a family member. So again, we look at the family dynamics. We look to see how the families get along. Is it a blended family? That can create some other issues. And then we look at the type of assets to determine whether a will or a trust works. So your will is just instructions to the court. Your trust is instructions to a trustee. But when I create a revocable trust, the way I'm getting out of probate is I'm titling the assets in my trust while I'm alive. So I'm going to connect my house to the trust, my bank accounts, my brokerage accounts, my stocks and bonds. So I'm either going to name the trust as the owner or the trust as the beneficiary. So when I die, if all the assets are in Amy Pittman's trust, my successor trustee, let's say Josh, my husband, will have immediate access once he gets my death certificate. So that transition from me being dead and someone having access is much faster than a probate process. And if my kid is out of state, they can put my house up for sale right away. And that's the benefit that you hear more about in this community, because my kids want to sell my house and the houses around here sell fairly quickly. The other benefit, you know, let's say like my parents have 7 kids. If one of us is in charge, you know, they want that one person to get access to the money first to cover expenses of the house until we can sell it, and then split it up 7 ways. Versus if you go in and name 7 kids as a beneficiary on their bank account, they just divided that account 7 ways, and now I'm in charge, but I'm out of the whole of the account. So again, it goes back to what type of family we're dealing with, how many beneficiaries, do they like each other? That really does play, the family dynamics really do play into whether or not we're gonna recommend a will or a trust. But think of the trust just like a will. It's just titling the assets different. So you're kind of doing the work ahead of time to make it a little smoother for the person in charge when you die. You're really doing it for the person in charge. You're not really seeing a true benefit. It's not an asset protection trust. You can still be sued. It's still your assets. You can deplete the assets, spend out in zero. You can change beneficiaries just like a will. But you have to fund the trust, and we talk about that a lot with my clients. We do funding workshops every month for current clients so they know they have to connect the assets to the trust.
So just to get that straight now, we can leave each one of our sons $11.7 million without inheritance tax?
They would love you a lot.
Write that down. We don't want to go over that.
No.
Now that changes based on who's the president, so we always keep that up. And one of the benefits of using us as a firm is we send out monthly newsletters, so we tell you if the law's changed and keep you up to date on that.
Okay, a nutshell answer. What would happen here in the villages if people came here without a will and passed away?
Okay, so in the state of Florida, and most states have an intestate statute. So
an intestate means?
Intestate means I died without a will.
Okay.
And my will is just directions. You know, if I have 7 kids, but I only want to leave to 5, or they only want to leave to me because I'm their favorite. So when you die without a will, they're going to find your next of kin, right? If I'm married, my spouse. If I'm not married, my kids. You know, so they'd still eventually get to the kids. It's not the state taking your money. Who takes your money in probate is the attorneys. We make the money in probate because we can charge a percentage of the value of the assets going in. So the more assets going in the probate, the more I'm going to make. So we try to reduce that when we have a will. So you're planning to have a will. Well, that's fine. Just don't have all your assets go into probate. Reduce it down to really the real estate if possible. But yes, if you die without a will, then the state of Florida has a statute, and every state does, that says who the next of kin is, and they will find someone. But you know, that's a big deal if it's a blended family, because if I'm married and I have 2 kids and I'm the one that died last, it's only going to my 2 kids. It's not going to my deceased spouse's 3 kids. So that's why you got to have this plan in place and address it with an attorney. Don't try to do it yourself. That you make sure that you're providing for everybody that you want.
Well, in the villages, as in lots of places, especially retirement communities, you have people in their 60s or 70s that have had 2 wives or 3 husbands or whatever with, you know, that yours, mine, and ours thing.
Yep.
And that's what a trust would help set things right before you go.
Well, it's supposed to make it cleaner. You know, people laugh. I tell my clients they're not to get married after their spouse dies because it can get really messy. Blended families, kids' expectations, being a caregiver. So it can definitely, as you blend assets or you combine assets, you know, if you're a married couple and you put an account in both your names, it's going to the surviving spouse, even though your kids may think it's going to them. It's not. And then that surviving spouse can come in and change their will, change their trust, and take your kids off in a heartbeat. And we see it happen all the time. So if you're trying to keep assets separate, you do not put them in both names of the spouses. It's all about how your assets are owned. So if I own that asset with my spouse, they can do whatever they want. If I have a trust that's just in my name and I'm putting the assets there for the benefit of my spouse so he can get income from it and use of the house, but I know that when he dies, the assets will go to my 2 kids, I can do that, but I have to have maintained ownership through the whole marriage for that to happen. And in Florida, if you're married, your spouse is entitled to half your house and 30% of all your assets, even if you put it in a revocable trust or have beneficiaries, unless you do a prenuptial agreement or a postnuptial agreement. So if you're a blended family right now and you've kept your assets separate, it is key that you have a prenuptial agreement before you get married. If you're already married, a postnuptial agreement, so that you both say, I'm waiving my right to that spouse's assets, so that your heirs or your people cannot sue for that 30%.
Wow, I didn't realize that. And by the way, that was refreshing a little bit ago when she gave us the lowdown on lawyers, that, you know, a lot of times it's lawyers that make the money, and you can avoid some of that by planning ahead. Can you tell us a horror story about wills or trusts or lack of?
Well, I had one probate where the son actually got the documents offline, do it yourself, had mom and dad go in and sign. Well, mom and dad thought they'd be good and do 2 wills. And it ended up costing that son more attorney's fees than what it would have cost had he done a will. It's not good. And then I've had clients who've done their estate plan and it not go the way they want because the way their assets were owned. So they're not realizing, hey, if I have a bank account and I'm going to name Amy as my beneficiary in my bank account for $50,000, and then in my will I say Amy gets $50,000 and my assets going through probate, well, I'm coming out with $100,000, but that client assumed that one was only going to get 50. She assumed that 50,000 over here would be coming from your will. So realize when you're doing a will, it's only those assets that have no beneficiaries. If you name a beneficiary on an account, so if you've disinherited your kid on your will, but then you go and name them on your IRA, they're still going to get your IRA. So understand that how your assets are owned completely controls. The biggest horror stories are people getting remarried and their spouse disinheriting their children. Maybe not right away, but eventually they disinherit. So, you know, again, after, you know, I've been practicing for 16 years, 14 years here in the Villages area, just doing estate planning and probate and trust administration. And that's my biggest issue is blended families, not keeping assets separate, and the assets ultimately going to the surviving spouse, which is fine if you both combine those assets and work together to create those assets, but eventually not going to the other person's kid. And that's sad because that's not the intent.
Well, it sounds like the answer is going to be depends. Somebody like Linda and myself, high school sweethearts, been married 43 years. Probably going to last, you know?
No, it will last.
It probably will.
And they're not going to get married again. How many kids do you have?
We have 3 sons.
And they like each other?
Yeah.
Yes.
So equal disbursement. I mean, you could easily get away with doing an equal disbursement on your bank accounts, pay on debt to my 3 kids. If they like each other, then they're going to figure out who's going to pay the cost of that house, right? If it takes me 90 days to probate your house, well, who's paying the utilities, the maintenance? Well, if those 3 kids get along, not a big deal. But if we got a crazy daughter-in-law sitting back there and in the background making comments about, well, you're never going to get reimbursed, or why are you doing this? That's not a good thing. So we always, in that worksheet that we give is, you know, do your kids get along? Do they like each other? Because that's going to determine a lot with the type of advice we give you. But yes, you could probably get away with just doing wills and having beneficiaries on everything, and all we're doing is probating the house. If you even own a house when you die, you could go move in with one of your kids when your first spouse dies and not have a house anymore.
Which one should we live
I'm
with?
sure your daughter-in-laws would love that.
She's a good cook. She would be a good cook and a nanny.
I'd be a good nanny.
So again, it sounds like depends. And my next question is going to be one that I don't think you can answer. How expensive is it to have a will or a trust?
So we have packages, and it can range from $600, actually sometimes $300. If they already have a will, we don't have to do the will package. We just do their power of attorney and health care, up to $2,500. So it will vary. It will vary if they're married or you're single. I mean, the consultation is free. So either myself, Amy Pittman, or Audra Platt, the other attorney here, we meet with you. We go over the worksheet, and then we make recommendations. And if you don't think we're a good fit, by all means, go to another law firm. But we do take what we do here as estate planning very seriously. And we have been here, like I said, I've been practicing here in the Villages area for 14 years. I actually grew up in Weirsdale. So if anybody's been on that side of town, that's where I grew up. But I moved to the big city of Ocala. But I love practicing here. This is a really cool community. It's a great bubble. I was talking to some clients today that we live in a bubble, and it's a pretty cool bubble. And the thing is, y'all are all in the same place right now. You're all thinking about this. So we have a lot of clients, you know, my biggest referral source is nextdoor.com and Talk the Villages. So everybody's talking about it, and we just want to make sure that people realize not everybody's plan is the same. Just because Joe got a trust doesn't mean you need to have a trust. Just because he did a will doesn't mean you should just be doing a will. So you really do need to sit down and don't oversimplify it. Yes, people don't have complicated estates very often, but you don't want to oversimplify your estate plan, because a part of your estate plan is not just your document, but the type of assets you have and the beneficiary designations that you have on those assets.
Well, it sounds like I'm going to have to throw that will I did off the internet away and make an appointment here.
We're going to start over.
We really appreciate you making
welcome.
time for us, and a wealth of information and presented in a very nice way.
Quickly, sorry I talk fast.
Well, we will put, if it's all right with you, we'll put your contact information
Definitely.
in the video description, and folks that want to talk to you or make an appointment can call your office.
Definitely. Thanks for having me.
Thank you so much.
Have a good one.
There you heard it. A lot of answers. Like we answer you all the time and we say depends, or we don't know, or find an expert opinion. We just found an expert opinion, and you can make an appointment and come in. But I think the important thing is to be financially prepared, not only for dying, but for living. You know, you're going to live a long time. So come in and make an appointment, and you'll figure it out.
Until next time.
See you when you get here.